Well, we note the ruling of the Magistrate of the Anti-Corruption Court, the Chief Magistrate of the Anti-Corruption Court. However, I wish to say it's not over yet. I will be proceeding to the High Court for a revision of that ruling by the Magistrate. I feel the Magistrate applied himself unfairly, and that was the application that I filed yesterday and was received by the Registrar of the Court. I wanted the Magistrate to recuse or withdraw from this matter, given the Judiciary Code of Conduct, and I've shared that document with you. It has the relevant authorities that a judicial officer who claims on record that facts do not matter, then should never sit into a matter because bias is influenced. If you read the ruling that he has made today, he seems to be already arguing the matter substantively without listening to the parties. I think it is time for the judiciary to address itself to the issue of private prosecutions at length. We are happy that today every household in Kenya knows there is a relief known as private prosecution. We will therefore not be the ones who betray the cause of us achieving what is offered by the law on private prosecutions. We will therefore ensure that we go to the highest possible level to ensure that we get the relief that is necessary for private prosecution. There is absolutely no doubt from a ruling by the High Court that has been quoted by this magistrate that CS Matiangi sought for a quality and standards report from his own ministry, which he ignored. Therefore, the issue that he was misled is moot. He was advised by his own ministry officials and civil servants that he should not buy public land. Article 107.1 puts the responsibility of purchase and compulsory acquisition of land right on the foot of CS Matiangi. Therefore, it does not matter whatever method that they use, whatever bias that is inherent, that so to achieve or to defeat justice, we will ensure that we go to the highest court in the land to ensure that justice is served. Thank you very much.
How about this application?
The application, we filed it yesterday. The purpose of the application was for the magistrate to recuse. The provisions of the law are that at any point a prosecutor can move to court and withdraw and file an application for recusal of a judge or a magistrate for that matter. But in the event that I raised the matter before he made the ruling, but he seemed to be saying that he would rather first of all dispense with the ruling because he knew what he was going to do. He was going to declare the court's functions official, and I raised that issue so that then I am not able to find anything else that can be had before that. The application seeks for him to withdraw from the matter and the matter be allocated to someone else because of what I believe was inherent bias during his first hearing. He claimed that facts do not matter. We all know that affidavits, by their very definition, is statement of facts. Therefore, a magistrate sitting to rule on a matter cannot say facts do not matter. Facts do matter, and they are the heart of any judiciary petition.
How soon will you be moving to the High Court?
I'll be moving for revision of the High Court immediately. I'm going to be sitting down with my research team, and we are going to compile whatever is necessary to come back to court, and you, ladies and gentlemen, will be informed once that is done.